Hello and welcome to Courts Today by Live Law. I am your host Urvashi Chauhan, here to keep you informed with the latest and most important updates from the legal world. As always, we will first cover the top headlines, followed by an in-depth look at each major update. In a judgment delivered today, the Supreme Court has reiterated that compassionate appointment is not a vested right. The top court has denied anticipatory bail to Odisha BJP PMLA accused of slapping a woman police officer. Regarding the stubble burning matter, the Supreme Court has reiterated concerns over reluctance of states of Punjab and Haryana to prosecute the officials for violating orders on stubble burning. The top court has observed that hate speech is not same as wrong assertions or false claims. The Supreme Court is set to hear the plea of acid attack survivors' challenges to complete live photograph requirement of the e-KYC process. A Delhi court has today ordered release of Aam Aadmi Party MLA Amanatullah Khan in the Waqf board PMLA case. The Supreme Court has dismissed the plea to direct doctors to specify side effects of medicines in the prescriptions. The top court has set aside the order removing Chhattisgarh woman Sarpanch from office, terming it as high-handedness by the state. And the Supreme Court today dismissed a plea to ban WhatsApp. The Supreme Court has held that compassionate appointment is not a vested right which can be granted without any kind of scrutiny or undertaking a process of selection. A bench comprising Justices Abhay S. Oak, Ehsanuddin Amanullah and Augustine George Massey was deciding the appeal filed by a man whose claim for compassionate appointment on account of the death of his father, a police constable, was denied. The petitioner's father died when he was 7 years old in the year 1997 and applied for compassionate appointment in the year 2008 after attaining majority. However, the Haryana government rejected the claim, citing the policy from the year 1999, which introduced a 3-year limit after an employee's death. The court explained that a compassionate appointment is not an automatic right granted to the family of an employee who dies while in service. Instead, it is an appointment provided after thorough review and strict assessment of various criteria. The purpose is to support a family facing sudden financial hardship due to the death of the family breadwinner. This assistance is meant to help the family manage an immediate crisis and is only granted if the applicant meets the requirements outlined in the relevant policies or rules. The court further said that the 3-year period from the employee's date of death within which a dependent must make the claim under the 1999 policy from the government of Haryana is neither unreasonable nor illogical, especially because compassionate appointment is not an automatic right. The petitioner had raised an argument that many other similarly situated persons were given compassionate appointment despite their applications being time-barred. Addressing this in its judgment, the court has stated that a person cannot claim equal treatment based on an illegal benefit conferred to someone else, as Article 14 of the Constitution cannot be used to perpetuate illegality. Thus, while the petitioner's request for an appointment was denied, the court permitted his mother to submit a request to the appropriate authority for a one-time ex gratia payment. The Supreme Court today dismissed the anticipatory bail plea of Odisha BJP MLA and ex-leader of opposition Jai Narayan Mishra, who is accused of slapping a woman police officer during a protest in the year 2023. After the incident, an FIR was lodged against him in February that year. Mishra approached the Odisha High Court for anticipatory bail, but the same was denied. Assailing the High Court order, he approached the Supreme Court. Initially, a division bench of Justices Roy and Prashant Kumar Mishra had granted him protection from arrest and sought response of the Odisha government. Today, Advocate Saurav Agarwal, appearing for Mishra, appraised the court that the state has recorded statements of all witnesses except Mishra, who has not been summoned till date. He further submitted that Mishra is willing to cooperate with the investigation, and in other cases where he is arraigned, he has been granted bail. A bench of Justices Rishikesh Roy and S.V.N. Bhatti rejected the plea for anticipatory bail, noting that it could prejudice the investigation. Noting that at the relevant time, the petitioner was leader of the opposition and is currently a member of Odisha Legislative Assembly, the court remarked that people in leadership positions must set an example for public behavior. Also, when the advocate Samapika Biswal representing the state of Odisha suggested that the court only ask Mishra to cooperate with the investigation, the bench sensed a leniency towards him. Criticizing this, the bench reviewed the state's earlier counter-affidavit filed under the Biju Janata Dal government, which had opposed the anticipatory bail for Mishra and detailed his background. Delhi residents woke up to severe air quality this morning following the worst air quality index in the country yesterday. Dense smoke covered the NCR, making visibility poor. Yesterday, the AQI had reached severe for the first time this season. The Supreme Court has reiterated its concern over the reluctance of states of Punjab and Haryana to prosecute officials that have violated the provisions of the Commission for Air Quality Management Act regarding stubble burning. A bench of Justice Abhay Oak and Justice Augustine George Massey was hearing the MC Mehta case concerning pollution management in Delhi NCR, focusing on issues related to vehicular pollution, solid waste management and stubble burning in the NCR states. Regarding air pollution from stubble burning, the court examined compliance affidavits submitted by the governments of states of Punjab and Haryana, which indicated a high number of farm fires during Diwali season. The court reiterated dissatisfaction over the reluctance of both states to take action against airing officials. The states were directed to file better compliance affidavits outlining actions taken within 3 weeks, with the matter to be revisited on 16th December. Also, the court observed a disturbing feature in farmers approaching the court with grievances about inadequate provision of machinery and equipment for stubble management. It emphasized that it is the responsibility of state governments to address these needs at their level. The court also directed states to begin imposing penalties under Section 15 of the Environment Protection Act 1986, noting the appointment of adjudicating officers for enforcing this provision. I must tell you here that the top court will hear the issue of pollution caused by vehicles on 25th November. The issue of the court's directions regarding color-coded vehicle stickers is set for further consideration on 3rd January 2025. Stay tuned. In the next update, the Apex Court today, while dismissing a PIL seeking guidelines to prevent provocative speech by political leaders, observed that the offence of hate speech cannot be equated to the act of wrong assertions or false claims that one may make. The plea filed by Hindu Sena Samiti through its president Surjit Singh Yadav stressed the need for guidelines to prevent the growing menace of delivery of provoking public speech, jeopardizing the sovereignty and endangering the security of the state. The bench of CJI Sanjeev Khanna and Justice Sanjay Kumar refused to entertain the PIL, considering that the court in the case of Shaheen Abdullah versus Union of India and others was already seized of the issue of hate speech. In the Shaheen Abdullah case, the court had instructed state governments to take immediate action against hate speech crimes without waiting for a complaint. It had directed that the cases should be registered on their own and offenders must be prosecuted according to the law, regardless of the speaker's religion. The court warned that any delay in following these instructions would be considered contempt of court. During the hearing in the present case, the CJI pointed out that the PIL misconstrued the offence of hate speech. The petition had referred to certain statements made by Congress MLA Sajjan Singh Verma in Indore in August this year regarding the public storming of residence of Sri Lankan President and Bangladesh Prime Minister. It also mentioned statements made by national spokesperson for the Bharatiya Kisan Union, that is Rakesh Tikait, in August in Meerut regarding the farmers' protest on Republic Day in 2021. The court, while dismissing the PIL, noted that elements of hate speech cannot be considered similar to the act of uttering wrong assertions or false claims by an individual, as both stood on different footing. The Supreme Court briefly heard a petition seeking guidelines for an inclusive KYC process for acid attack survivors and persons with permanent eye damage. The main petitioner, who is an acid attack survivor herself suffering from severe eye disfigurement and facial damage, cites the challenges that she faced while attempting to open a bank account. During the process of opening, she was deemed incapable of completing the digital KYC as she could not fulfill the requirement of a live photograph taken by blinking her eyes. Senior advocate Siddharth Luthra, appearing for the petitioners, informed the court that earlier there used to be paper-based identification. Now there is a requirement for taking live photographs, which requires eye movement. He explained that that may not be possible for the acid victims. Therefore, it has led to a whole degree of exclusion. Thus, directions have been sought to the central authorities for framing appropriate guidelines, providing for alternative methods to conduct the digital KYC or e-KYC process for acid attack survivors suffering from permanent eye disfigurement or eye burns, with the view to make the process more accessible and inclusive towards all disabled persons, particularly acid attack survivors. A bench of Justices J.B. Pardiwala and Pankaj Mittal heard the matter. Considering that the matter would require some time to be heard, the court directed the respondents to file their responses within 4 weeks. The matter will now be taken up on 21st January 2025. In another update, a Delhi court today ordered release of Aam Aadmi Party MLA Amanatullah Khan in a money laundering case connected to the alleged irregularities in the Delhi Waqf Board recruitment during his chairmanship. Special Judge Jitendra Singh refused to take cognizance of Enforcement Directorate's supplementary charge sheet against Khan under PMLA for the lack of requisite sanction in terms of Section 197, Clause 1 of CRPC. The judge added that no sanction from the competent authority or government was placed on record against Khan. The case alleges that Amanatullah Khan, while working as chairman of the Delhi Waqf Board, illegally recruited various people in violation of norms and government guidelines. The Enforcement Directorate has alleged that Khan acquired huge proceeds of crime in cash from illegal recruitment of staff in the Delhi Waqf Board and invested the same to purchase immovable assets in the name of his associates. Khan was arrested by ED in September after searches were conducted by the Central Probe Agency at his residence. In the next update, the top court today dismissed a plea seeking mandatory disclosure by medical professionals or doctors of the risks and adverse effects associated with drugs that they prescribe to the patients. The petitioner sought a direction that all medical professionals should specify to patients in the form of an additional slip in the regional language along with the prescription all kinds of possible risks and side effects associated with a drug or a pharmaceutical product being prescribed by them. Advocate Prashant Bhushan for the petitioner argued that a large part of harm to patients is associated with adverse effects of medicines. It was claimed that though pharmacists have an obligation to put a note inside the medicine package box as to what are the contraindications or adverse effects of the subject medicine, there is no similar obligation on doctors. A bench of Justices B.R. Gawai and K.V. Vishwanathan, however, expressed that the prayer was not practical, in as much as general practitioners would not be able to attend more than 10 to 15 patients if the practice was allowed. Besides, pharmacies are extremely crowded and there are likely to be large number of consumer cases. Justice Vishwanathan also said that the only thing that can be done is to have a board displayed in pharmacies in the local language which advises the buyer or the patient to read the medicine cover properly. The petitioner had earlier approached the Delhi High Court in this case, which dismissed his petition, observing that it was a matter of legislative policy. The Apex Court today set aside an order removing a woman Sarpanch from office in Chhattisgarh and directed inquiry into the officials who caused unwarranted harassment to her. The court further imposed a cost of 1 lakh on the state government. Let me tell you, the appellant, a 27-year-old woman, contested the election of Sarpanch of Sajbahar Gram Panchayat held in 2020. She was elected with a good margin. The Gram Panchayat was allocated some development works, including 10 construction works of roads, etc. A letter issued in December 2022 by the Chief Executive Officer to complete the works within 3 months was served on the Gram Panchayat in March 2023. The appellant was accused of delay in the construction works. In May 2023, she was issued a show cause notice and later tendered her explanation denying any delay. However, she was removed from the office of Sarpanch in January this year. She approached the High Court for relief, but to no avail. Assailing the High Court's rejection of her prayers, she approached the Supreme Court. A bench of Justices Suryakant and Ujjal Bhuya heard the matter, coming down heavily on the state for causing undue harassment to the elected woman Sarpanch on the pretext of delay in construction work. The court granted relief to the appellant today. Justice Kant criticized the Chief Executive Officer for issuing an arbitrary order without technical knowledge of the time needed to complete the construction. The judge also highlighted that the authorities unfairly targeted a woman Sarpanch who, despite challenges, was elected and dedicated to rural development. Further, the court directed the Chief Secretary of Chhattisgarh to release the cost of 1 lakh to the appellant and hold an inquiry to find out the officials responsible for her harassment. And lastly, the Supreme Court today dismissed a public interest litigation seeking directions to the central government to ban the operation of WhatsApp for its alleged violation of orders of legal authorities in the country. The petitioner, a software engineer, had first moved the Kerala High Court seeking a ban on WhatsApp, alleging that it did not function in conformity with the Information Technology Rules 2021. The petitioner also claimed that there was a wide scope of manipulation at the user end and that it was not viable to trace the origin of a message being circulated on the application. It was alleged that WhatsApp refused to comply with the IT rules as it violated the privacy of its users before the Delhi High Court. WhatsApp had challenged the traceability of Information Technology Rules 2021, arguing that it violated a person's right to privacy as protected by the K.S. Puttaswamy judgment. The petitioner further stated that the updated privacy policy openly mentions that the application will store, access and use the personal data of its users, including the battery remaining on their devices, which are a grave violation of the right to privacy. The petition also alleged that WhatsApp had implemented a separate privacy policy in Europe in compliance with their laws. Yet, the app refused to comply with the laws in India. But the petition was dismissed by the Kerala High Court in June, prompting the petitioner to approach the top court. The counsel for the petitioner today submitted before a bench of Justices M.M. Sundaresh and Arvind Kumar that the High Court's rejection of the PIL was simply based on the ground that the plea was too premature. However, without hearing anything further, the bench dismissed the petition. For more details on the cases that I mentioned, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe to our channel. You can support us by donating through the thanks button at the bottom of our videos or by becoming a member for just 89 rupees per month.